Hello everyone. This is a criminal procedure adjudication video topic, and it's linked to Chapter 10, Part A2 in the Miller and Wright text. We're talking now about appeals, direct appeals, and particularly here the specialized procedures and doctrines that we use when defendants who don't have money to retain their own lawyer decide to appeal their convictions. Away we go. Now let me start by setting the scene for appeals. They're scarcer than you think. When you study criminal procedure, you tend to consume a steady diet of appellate judicial opinions. This selection of teaching materials can lead to a mistaken impression that every case ends in an appeal, but most criminal cases never make it to the appeals level. Why are there so few of them? Part of the answer is based in the law of appellate practice. The Arkansas statutes that we have here are fairly typical in this regard. They say defendants can appeal their convictions, but it's a person who's convicted of a misdemeanor or a felony by virtue of a trial. This excludes, of course, the guilty plea people. Now, there are special rules for guilty pleas in Arkansas, so it's still possible to have an appeal after you plead guilty, but only if you enter a conditional plea. Only if you say to the court when you're entering your guilty plea, look, I think there's a pivotal issue of law here that relates to some search and seizure issue that I have raised and you have decided, I believe, wrongly. I'd like the appellate court to review that, but once we reviewed that, it's game over. If I lose there, it's game over for me. So defendants are allowed under certain circumstances to enter this conditional plea of guilty. I mentioned search and seizure issues. There are also confession issues and in Arkansas, speedy trial motions. But think about what's not on that list. There are a lot of possible legal challenges to the validity of a conviction that are not available to challenge on appeal under these Arkansas rules. And the same is true in most jurisdictions. There are at least some limits on what you can raise by way of to the appellate court once you have entered a plea of guilty. Let's think about the long-term historical trends here. Appeals are increasingly more common than dispositions at trial, but appeals aren't growing fast enough to keep pace with guilty pleas. So you have in front of you some federal numbers between 1991 and 2009. You see that just the raw number of appeals grew over that time. But what's interesting is how that compares to changes in different trial dispositions. So if you're comparing appeals to the number of guilty pleas at the trial level, guilty pleas are growing faster. So the ratio of guilty plea convictions to appeals has gone from 4 to 6. Basically, there used to be 4 times as many guilty pleas as there were appeals, and now there are 6 times as many guilty pleas as there are appeals. At the same time, really interesting, trials are disappearing in the federal system and to a lesser extent in most state systems, although it's a more pronounced trend in the federal courts. Trials are going away in absolute numbers. There are fewer trials today than there were back in 1991. And just in terms of comparing the appeals to the trial convictions, you have appeals still growing, not as quickly as guilty pleas are growing, but they're still growing while appeals are shrinking. And so the ratio of trial convictions to appeals is sinking. The big phenomenon here is the growth of guilty pleas, and appeals are trying to keep pace, but they're not. They're growing, but not as quickly as the guilty pleas are. Based on the rules that we reviewed earlier, lots of guilty plea defendants are not eligible for appeal. So appellate courts don't hear a random cross-section of cases from the trial level. For one thing, as we've seen, they hear less frequently from those cases where the defendant pled guilty. Another major skewing effect in the pool that the appellate courts hear is that most appeals are initiated by the defense rather than the prosecution. Partly this is based on double jeopardy grounds. The prosecution under double jeopardy doctrine can't file an appeal after they lose a case at the trial level, say get a jury acquittal. They can't appeal that, get a reversal, and then go back and retry the defendant. Even if the acquittal was based on some kind of wrongful legal decision, say the decision to exclude evidence by the trial court. Now there are a few exceptions to this. So there are a few prosecutor-initiated appeals that are allowed. There are some interlocutory appeals that are allowed. And then there are in a few jurisdictions, something called a moot appeal. Our Delaware statute here gives us an example of some of these interlocutory appeals. So in Delaware, notice that even though the common law says that the state has no appellate rights, the state does have an appeal as of right if you've got at the trial level a final order that constitutes a dismissal of an indictment. So if the prosecution files a case and the judge says, nope, not sufficient, I dismiss this case, and it never makes it to trial, that is, double jeopardy never attaches, then the government is allowed to appeal that pretrial legal decision. And if they win on appeal, they can go back and get their initial trial of the defendant. The same is true for certain pretrial rulings on evidence. If the government loses a motion to suppress and their key evidence is knocked out of the case before trial, then the rules and statutes in most jurisdictions allow them to appeal that decision, particularly if somebody within the Department of Justice or the executive branch certifies that that was our critical evidence. And again, if they win and the trial court has to let the evidence in, then you can send it back to the trial court and have that initial trial, this time with the evidence properly included. So those are the interlocutory appeals that are allowed. A few jurisdictions also do a very interesting thing called a moot appeal. Delaware, Section 9903, not pictured on your slide here, is an example. It allows the prosecution to bring an appeal even after an acquittal, and they can argue whatever their legal objections were to what happened at the trial court level. But then if the government wins, the win doesn't mean anything for this particular defendant. So in that sense, it's a moot appeal. It is precedent going forward, but it doesn't allow for a retrial of this defendant. Who's representing this defendant who's got nothing at stake? In these jurisdictions, typically it's the public defender who will have recurring clients who might be able to benefit from the rulings of the trial court below. So when you put these double jeopardy doctrines together with the limited interlocutory appeals and moot appeals that are allowed for the prosecution, what you end up with is a pool of cases coming before the appellate court that are by and large individual defendants who have decided to appeal, along with just a smattering of prosecutor-initiated appeals. Typical numbers, if you've got a state prosecutor's office that handles maybe 10,000 cases a year, including all the guilty pleas and various misdemeanors, they may only initiate appeals in a dozen cases. Different numbers in different places, but those are fairly typical numbers. So who are these defendants who are bringing the appeals? We've already seen that they're disproportionately defendants who went to trial rather than those who pled guilty, although there are some guilty plea defendants mixed in, especially if they if they entered a conditional guilty plea. But what about money? Money makes a difference throughout the criminal process. Is money in part driving the decision of defendants as to whether they're going to bring their appeals? The Supreme Court has relied on both the Equal Protection Clause and the Due Process Clause. Sometimes it's hard to tell which one they're really relying on, but over the years, a string of rulings that try to close that gap between the defendants with money and the defendants who are indigent, trying to give indigent defendants access to appeals, at least if the state provides for appeals. Remember, an appellate process is not a constitutional requirement, but if the state provides for an appeal as of right, then it must provide certain support, like access to transcripts, access to lawyers on that direct appeal that will equalize them to some extent with defendants who do have money. I won't go through all the rulings. Some of the major ones are listed on the slide here, but there is a robust body of doctrine under the Equal Protection Clause and Due Process Clause that try to give indigent defendants access to the appellate rights that are provided to other defendants by the state system. What does this appellate lawyer do for a defendant, whether it be an indigent defendant or some other defendant? It's a tricky question for the lawyer because lawyers are officers of the court. They can only raise colorable claims to the court. And yet in the criminal appellate arena, the defendant can insist on an appeal. We call it an appeal as of right. And that might be based on claims that the lawyer doesn't believe are colorable. So how does the attorney reconcile these conflicting duties to the client to be a zealous advocate on the one hand, but also to the court to be an officer of the court and only raise colorable claims? Our illustrative case on this dilemma is Mosley versus State. So our defendant here, Brian Mosley, got a little too rowdy at a Bubba's Bar and Grill. Don't you just love that name? And by the way, we have here a picture from the interior of a Bubba's Bar and Grill in Indianapolis. Although by my last count, there are 3 locations for Bubba's Bar and Grill in Indianapolis. So can't be sure this is the very place, but something like this you can imagine. Anyway, during the arrest, a couple of officers are arresting him, and he gets his right hand handcuffed, put behind him, and then he starts flailing his left hand, and it appears maybe he's trying to strike one of the officers involved. He's ultimately charged both with misdemeanor resisting law enforcement plus a misdemeanor criminal trespass, but at the bench trial, the judge only convicts him of the resisting law enforcement officers, and so he's sentenced to almost a year of probation. On appeal, he's challenging the sufficiency of the government's proof of one of the elements of the resisting law enforcement crime, and that is the use of force element. But the Indiana Court of Appeals is not amused. They declare that this brief raises what was not at all a close question. When the case gets to the Indiana Supreme Court, of course, on the outcome, they affirm the Indiana Court of Appeals, and they say, yeah, there was sufficient evidence here that use of force element is not a winner for the defendant. And by the way, whenever a defendant on appeal has as their one and only argument sufficiency of the evidence, you can predict pretty reliably that that defendant is going to lose. But putting aside the merits of the appeal, the Indiana Supreme Court also addressed the duties of counsel. And here they point out the special obligation to the court embodied in Model Rule of Professional Conduct 3.1 that says that an attorney at any level, the trial court level or the appellate level, can't assert an issue unless you can conclude that it's not frivolous. You know, if it's a frivolous issue, you can't raise it. But frivolous is defined very broadly under this rule, and it includes any good faith argument for an extension, modification, or reversal of existing law. Now, you can imagine that some sufficiency of the evidence arguments are just rejected so consistently, so frequently, that it's hard to believe that there's any kind of good faith argument for reversal of existing law. But at any rate, the court notes that this obligation built into the Model Rule of Professional Conduct is somewhat in tension with the lawyer's obligation to zealously represent a client who, under equal protection doctrine, does have equal access with all other defendants to the appellate rights granted by the state. Now, how does federal law reconcile these conflicting duties of the lawyer? Duties to the client for zealous representation and duties to the court as an officer of the court not to raise frivolous arguments. Well, in Anders versus California, 1967, the court said, you've got to do something distinctive here. You don't just file a normal brief. Instead, if the defense lawyer, for an indigent defendant believes that the case is wholly frivolous, then the lawyer is supposed to advise the court, first of all, by requesting permission to withdraw, and then accompanying that motion to withdraw should be what's called an Anders brief. which just refers to anything in the record that might arguably support the appeal. Part of the Anders procedure is not only to file your motion to withdraw along with your Anders brief, but you're supposed to provide to the client a copy of your Anders brief in time to allow the client to raise objections to the position that you're taking. And then in light of all of this, the Anders brief, your motion to withdraw, along with any objections that might come from the client, the appellate court can then either grant the motion to withdraw, which would mean, in effect, dismissing the appeal, or deny the motion to withdraw, and then you go forward and argue the appeal as normal. So that's the Anders process. Now, what does the Indiana Supreme Court do instead? Well, Justice Theodore Boehm, who's pictured on this slide, in effect says just file a regular merits brief. This is the position, in effect, taken by the ABA in its standards for providing defense services, going back as far as 1968. And a few states like New Hampshire, California, Georgia, Massachusetts do the same thing. They just say, just send us a regular merits brief. Now, why this rather than the Anders brief? First of all, this minority of courts that go beyond Anders and say you're just going to have to file a regular merits brief point out that there's just something that is disloyal to the client to turn in a brief with a white flag of surrender waving on the brief, saying, you know, I'm filing this, but I don't believe there's anything to it. That just seems too much of a conflict with the normal posture of defense lawyers and the normal duty of zealous representation. And in the end, the court says it doesn't save the lawyer that much effort because you still have to review the whole record and you have to write something. So it may be that writing the merits brief takes almost no additional time. The court also points out that there's a confusion of roles going on here. It puts the lawyer in the position of acting like a judge evaluating the claims rather than just raising the best claim that's available. And so as the Indiana Supreme Court puts it, a defendant is entitled to review by the judiciary, not by, interestingly here, overworked and underpaid public defenders. So, you know, the idea is that judges should be judges and judges face fewer caseload pressures. They have somewhat more control over their own docket. Not so much in a direct appeal sense, but the Indiana Supreme Court sees it that way because they have discretionary review for a good chunk of their docket. Finally, the Indiana court points out that whatever savings might come for defense counsel in a sort of streamlined effort in the Anders brief is just shifted over to the court because the court itself has to be a little bit more careful and invest a little bit more in looking at the record. And as the court puts it, they have to take on the precarious role of the advocate. They just have to act out of their normal routine or their normal perspective on things. And the court believes that no good can come of this confusion of roles. But I do want to stress that most states still do follow the Anders procedure, and this is a minority position that the Indiana court is describing and justifying here. Let me make two closing comments. First of all, you can wonder how much practical difference this whole debate will make. Will an Anders brief jurisdiction produce meaningfully different results than a full merits brief jurisdiction, either in terms of the cost to the lawyers, the cost to the court, or just the outcome on the appeals? Appellate courts, you know, you can imagine, could spot the meritorious issues in even in an Anders brief. So, you know, it's an interesting question. I don't know that there's a clear-cut empirical answer. Somebody ought to study that. You hear me saying this all the time. And finally, let me ask whether indigency is the issue here in this appellate counsel context. Think about the retained attorney on appeal. The attorney will review the record for the paying client and will say to the client, you know, I've read the record. The only thing we've got here are frivolous issues. There is no way the appellate court is going to reverse this conviction. It'd be a waste of your money to pay me to look into this any further and write the brief. So you can imagine maybe the defense lawyer talking some paying clients out of an appeal. On the other hand, you can imagine some clients saying, no, go ahead. Either, our contract includes the price of the appeal in what I've already paid you, or you've already reviewed the record and it's not going to cost me that much more to go ahead and file the appeal. You can base it on various of your trial briefs, or just, I got the money and this is the important thing to me and let's go ahead and take a long shot. The retained attorney still faces this dilemma of how do I reconcile my obligation to this client who wants to press ahead with my obligation to the court not to raise frivolous issues. Normally the way this is resolved is frivolous is just defined so narrowly. There is just so much ground to go ahead and raise a claim, because as long as there's some reasonable basis for arguing that for an extension of the law, as long as it's colorable within the meaning of the model rules, then the lawyer's not going to have any run into any ethical problems with the courts. So that's it for our doctrinal walkthrough. When we get together next, let's be ready to talk about the statistics for appeal and the practical realities of possible differences between indigent defendants on appeal and paying clients on appeal. And let's ask this question. Should appeal be treated differently from other stages of the process when it comes to the role of money? We'll talk then.